ability to pay restitution.
All right, pause right there. Because when a judge is described as swinging a gavel karma, that's not hype, that's foreshadowing. This isn't a slap on the wrist situation. This is a court saying, you had chances. You wasted them. Now it's time to pay. Buckle up.
He's being sentenced for crimes that include felon in possession of a weapon to organize crime and home invasion. This one gets explosive, so sit back, relax, and like and subscribe. Set your notifications to all. Let's roll, nerds.
The court has considered the record, the oral statements made, the victim impact statements, the trial testimony and evidence, the pre-sentence report from several years ago, the updated criminal history, my conference in chambers with counsel and probation, and the statements of the defendant and the defendant's counsel. The court has also considered the overriding purposes of felony sentencing pursuant to Revised Code 2929.11, try to protect the public from future crime by this offender and others similarly minded, and to punish the offender and to promote the effective rehabilitation of the offender using the minimum sanctions that the court determines.
This part might sound boring, but it's actually huge. The judge is legally required to explain why the sentence is fair. Not emotional, not personal, but balanced. Protect the public, punish the offender, and still avoid wasting taxpayer money. Translation? The court is building a bulletproof record for appeal.
Accomplish those purposes without imposing an unnecessary burden on state or local governmental resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've considered the recommendations of the parties, including the sentencing memoranda. I have reasonably calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society and the victims, and to be consistent with sentences imposed for similar crimes committed by similar offenders. In using my discretion to determine the most effective way to comply with the purposes and principles of sentencing, I have considered all relevant factors, including the seriousness and the recidivism factors set forth in Divisions B through E.
Notice what just happened here. The judge is checking off Ohio's sentencing checklist in real time. Seriousness? Check. Recidivism? Check. Prior history? Oh, big check. When a judge lays it out this cleanly, it usually means the defendant is about to get hammered.
Of Revised Code 2929.12. In that regard, there are factors making the offenses more serious. The victim suffered serious psychological and economic harm. I'm talking about Mr. Gonzalez. I believe he needed psychological treatment as a result of this. The economic harm was substantial. The Murillos suffered significant psychological harm for the home invasion that occurred as they arrived at their place of residence. This was committed as part of an organized criminal activity. There were 3 people involved in this.
This is where things turn ugly. Organized crime, multiple victims, psychological trauma, home invasion. Those aren't just aggravating factors. They're sentencing multipliers. And when a judge says there are no factors making this less serious, that's legal speak for there's no mercy left on the table.
There are no factors making the offenses less serious. In terms of recidivism, the offenses were committed while on post-release control from the previous time that I sent the defendant to prison for a crime of violence. The defendant has an extensive previous criminal history and history of juvenile delinquency. He's been to prison 3 times on 4 cases. He's got 9 prior crimes of violence before this case. She's got 11 instances of probation violations, resisting arrest, obstructing justice, and contempt of court, and numerous convictions. He's been arrested on 4 other crimes, plus this case, while on post-release control. The defendant was placed on PRC on November 15th of 2017, a 3-year period, and yet committed this offense less than 8 months later. There's a pattern of drug or alcohol abuse, and the offender refuses to acknowledge a problem or accept treatment. There's been a rehabilitation failure after previous convictions and delinquency adjudications, and a failure to respond.
Let's be real, this resume is brutal. Multiple prison terms, probation violations, crimes of violence, and committing new crimes while already on post-release control? Judges absolutely hate that. Quick question for you watching. After how many chances should the system finally say enough?
Passed to probation for post-release control. The court determines that the offenses were committed under circumstances very likely to recur, and the court determines to make recidivism less likely that the offender shows a certain amount of remorse, or determines, though, that the defendant poses the greatest likelihood of committing future crimes. On the felony 4, the CCW, there is no presumption in favor of community control because of the PRC violation and the prior prison terms, and because it was possession of a firearm. On the 2 felony 1s, there is a presumption in favor of prison, and there is not a lick of evidence here by which the court could override that presumption in favor of prison. The court determines that prison is needed to protect the public from future crime, that a minimum sentence would demean the seriousness of this offender's conduct. The court believes that consecutive sentences are necessary to protect the public and punish this offender. They would not be disproportionate to his conduct and the danger he poses. That the crimes were committed while on post-release control. That the harm is so great or unusual that a single term would not adequately reflect the seriousness of his conduct, and his criminal history shows that consecutive terms are needed to protect the public from future crime. Accordingly, it is the sentence of this court, Anson Bryant, that you serve a period of incarceration in state prison. The court hereby terminates your post-release control, and I am imposing the balance through November 15th of 2020. I believe that comes up to 623 days, according to the DRC's calculation. Court sentences you to prison on count 1, aggravated burglary, felony 1, for 8 years, and 3 years on the firearm specification. Court sentences you on count 3, aggravated robbery, felony 1, to a period of incarceration in state prison for 8 years, plus 3 years on the firearm specification. The court sentences you on count 6, weapons under disability, felony 3, for 36 months. And on count 7, CCW, felony 4, for 18 months. The court makes the 2 weapons charges, count 6 and 7, concurrent with each other and concurrent to all of the other charges. The offenses, however, the court makes the 2 F1s consecutive with one another, and therefore the order of serving your prison time would be PRC time first, followed by the gun spec on count 1, followed by the gun spec on count 3, followed by count 1, followed by count 2, for a total of 22 years.
And there it is, 22 years. Consecutive sentences mean none of this overlaps. This is the court's way of saying the danger didn't come from one mistake. It came from a pattern, and when the judge later says no remorse whatsoever, that seals the deal for maximum time.
With credit for 231 days. The court determines that you have or will have the ability to pay restitution. The court determines that the defendant has shown no remorse whatsoever. I was giving him remorse, a certain amount of remorse in mitigation of the sentence. The defendant has shown me that he has no remorse whatsoever, and therefore the court determines that maximum imprisonment is needed. He poses the greatest likelihood of recidivism. So I believe I stated that restitution in the amount of $1,298 to victim Arturo Gonzalez, judgment rendered for that amount to be monitored by the Ohio Adult Parole Authority, payable through the clerk of courts. Defendants to forfeit all items in the specification, being the pistol and ammunition, pay the costs of confinement, prosecution, supervision.